All right, great. It looks like we're recording, and so thank you very much for joining us. And Jeff, I'm going to go ahead and turn it over to you with the U.S. Patent and Trademark Office to talk about the top things entrepreneurs wish they knew about patents and trademarks.
All right, well, thank you very much, Paul. As Paul said, my name is Jeffrey Pelnick. I'm a primary patent examiner with the United States Patent and Trademark Office, and I am here today to discuss several of the key things that most entrepreneurs wish they would have known ahead of getting into the filing for a patent application. So bear in mind, this is not meant to be an all-inclusive list of things, but it's just more of like a top 5 things, for example. Some of the top 5 things from maybe even like an examiner's perspective that maybe entrepreneurs wish they would have known, or some of the top 5 things, some of the key things that we see on a day-to-day with our examination of patent applications. Um, so here we just quick little legal notice: if at all, any sort of uh, familiar logos or companies or anything get mentioned throughout the presentation, this is just simply a disclaimer just to let you know that we don't endorse them. We're just simply using them as an example for the purposes here of this presentation. So, all right. So one of the big questions that we usually get with our presentations is, why do I want to use IP? Why do I want to bother going through IP? So with a number of our presentations, we give, for example, with intellectual property in general, we give presentations that provide higher level, and in some cases more detailed levels of the granular steps of getting various types of IP. We focus primarily on obtaining patents and trademarks. From my end, I focus primarily on patents. So this this presentation is more than likely going to be very patent centric, with a smattering of trademark worked in with it. But one of the big questions that we usually get is, why do I want IP? Well, one of the big reasons that you want to get IP or intellectual property is primarily because it really rings true with that second term. It is property. It is something that you use to corner your particular area of the market. It is something that you get so that you can exclude others from using your invention. It is property that is meant to be sold, licensed, or used to exclude other people from using your inventions. So, why do we want to use IP to grow your business? Pure and simple. The statistics just pretty much speak for themselves, and these are statistics that come out of actually an update to one of our favorite go-to references that we often cite, particularly when we talk about IP and how it can relate to business, what the advantages are. So businesses that or industries that employ IP or have IP as their basis, or employ um, technical minds that involve intellectual property, oftentimes are able to form companies that can provide their employees larger weekly salaries, can employ a larger number of full-time employees, provide other such benefits like more health coverage. They can oftentimes grow to be a larger company, and they oftentimes attract workers with uh, advanced degrees, if not more so. So one of the real reasons that you want to grow your business using IP, or have IP as your basis, is that it oftentimes shows that you have something tangible, something, I mean, even though intellectual property is meant to be a representation of the intangible intellect, if you have that solid basis of intellectual property at the basis of your business, a lot of times your venture capitalists, for example, are going to see that as maybe collateral, maybe as like, it's not just a fantasy idea. This is something that is actually going to be implemented and uh, created and eventually grown. So one of the other big questions is, um, what type of IP is right for me? So when you want to consider going back to that question of, why do I want to grow my business use IP to grow my business? One of the questions that usually goes hand in hand is, well, what type of IP is going to be right for me? Um, are you going to want to get a copyright for your business if it's going to be drawn to, um, if you're going to be designing your business around a particular manufacturing process? Maybe yes. Is it possible to get multiple forms of intellectual property? Absolutely. Different types of intellectual property offer different types of coverage and different levels of coverage. So one of the big questions out of the gate is what type of IP is going to be right for your particular business? And pure and simple, that is something that we just demur and say that is going to be a business type decision. We can't necessarily make that recommendation for you. We can provide you the information, though, that will help you along with that decision process. So, as the slide shows, we have four main types of we have four types of intellectual property. We have patents, trademarks, copyrights, and trade secrets. Now, if you've attended any of our presentations, particularly Path to a Patent, since I just partook in that event today, we go into a little bit more depth as to what the different types of intellectual property entail. So trade secrets, pure and simple, they're secrets. That's a form of intellectual property that's probably one of the easiest to discern because it relies on you, the business owner, to keep that information, that invention, that particular invention secret to you, either by non-disclosure agreements or some different manner by which you can securely keep that a secret. It's usually known to very few people and kept within the company, and has, it can have a delicate sense of being released, because if you're familiar with the phrase loose lips sink ships. If you have someone disclose it that shouldn't be disclosing it, then the secret's out there. Another way you can also lose the trade secret is if by chance someone invents the same thing at the same time, or if it's just similarly co-developed at the same time, just pure happenstance, or you could publicly disclose it yourself on purpose. Copyrights are tangible forms of expression. So any kind of artwork, any kind of publication that you can think of, your movie, your music, the lyrics to a movie, the script to a movie, works of art. If you've watched a baseball game on TV, you'll hear that please do not reproduce this without the express written consent of Major League Baseball. That is a statement indicating protection of copyright. Also, the dead giveaway is anything with the circle C next to it is something that has been officially copyrighted by the Copyright Office, not the Patent Office, the Copyright Office in the Library of Congress. And then the last two most common forms of intellectual property that you're apt to encounter are trademarks and patents. So trademarks, of course, there's the TM, and then there's the Circle R. The Circle R is the version that is registered by the Patent Office. Has been searched and is protectable throughout the land. The TM and the SM that you may see next to a given name or logo or phrase, that is more of a localized version and can vary from state to state, more of a regional form of trademark. And those are going to be subject to regional protections. So if you're using it, then it's going to be on you, the owner of the mark, to pursue protection with that. But if you register the trademark, things get a little bit easier, because then you have the Patent and Trademark Office on your side to help you work through any potential disagreements. And then lastly, of course, we have patents. Now, there's three types of patents, as you may or may not know. The bulk of the patent file applications and grantings fall within the utility category, and those form around your compositions, your processes, your manufacturing methods, your apparatuses. There's also design patents, which are meant to simply protect the ornamental status of an invention. So if you have, say, like a statue or a picture of a statue it's going to protect the ornamental. The statue in and of itself it could function as a paperweight for all you know or care. But a design patent is not going to protect its functionality as a paperweight. It's just going to protect the way the paperweight looks. Plant patents then are also directed to man-made plants. QD oranges are I think the go-to for our office to refer to also poinsettia plants. What is notable about those is that these are made from natural plants, but they do necessarily involve hand and man, so that you are not trying to gain a patent for natural product, because trying to do that is something that we deny patent applications for. Um, so yeah, that's a quick and dirty run through of the different types of intellectual property. We also do get a fair amount of questions about provisional versus non-provisional applications, and this is very localized to utility patents, utility patent applications in general. So a provisional application is a way that you can potentially get an extra 12 months of protection on top of getting protection for your non-provisional application once it has been allowed to, once it has been granted as a patent. So there are some subtle differences, but by and large, the key difference between a provisional and a non-provisional patent application, excuse me, is that the provisional application is not required to have any claims. To that end, there are no claims associated with an application to be examined. Therefore, a provisional is never examined. It is never made public. Um, One of the other key differences is that a provisional has a time frame of 12 months. If nothing is done with the provisional before that 12 months, after by the time that you get to 12 months, it is automatically abandoned. One of the big things that you want to remember about a provisional application versus a non-provisional application is if you are seeking to get the effective filing date of that provisional application, that is the protection as of the date that you file that provisional, you want to make sure that the exact same material that is covered in the provisional finds its way to the non-provisional. And then any claims that result from that non-provisional application, as long as they have support in the non-provisional and the provisional, then you get that extra up to 12 months of protection. Um, and basically, what that offers you is, if you want to think about it as an extension backwards, that's where we as examiners conduct our search. So we look to see what has been done before your application. So if there's an extra 12 months, in advance of when you filed your non-provisional application, that leaves us 12 months less to search for what may have been done. So if something was done between when you filed your, if something was filed between when you filed your provisional and your non-provisional, that's, we cannot use that as art or references against your application, and it's probably going to be unlucky for the person that filed in the interim. So, but that is one of the big questions that we get about what things that should be known about forms of intellectual property. And that's actually, that provisional versus non-provisional is one that's generated quite a bit of conversation and Q&A in many of our presentations, because it's something that people don't necessarily know. And the fact that people oftentimes misrepresent provisional. I'm trying to get my provisional patent. Well, there's no such thing as a provisional patent, because provisional applications in and of themselves are never made into patents. They can result in something that becomes the patent, i.e. the non-provisional, but they themselves are not. So part of the reason I bring this particular topic up is to dispel some of the misconceptions are oftentimes result from this discussion. Okay, so one of the next big things ahead of applying for your IP. And again, this is going to be more patent and trademark centric. Copyrights are unfortunately not my forte, and then trade secrets, since they are secret, and our office focuses on public dissemination of knowledge for exclusion of your intellectual property rights. We do not deal in trade secrets. So one of the big things that entrepreneurs can help themselves greatly with, ahead of filing their applications or ahead of trying to secure their IP, is to do their own research. It sounds like we're passing the buck, but one of the things that you can help yourself greatly with is to know where to go and how to do your own research. And uh, I'm going to use this opportunity to make a shameless plug for our Path to a Patent series again, specifically part 3, which focuses historically. It is every time our searching discussion, our searching session, and we usually have a searching expert not usually, we always have a searching expert on hand to give that presentation, to give a more in-depth discussion and detail about what I'm about to go through very quickly here. So one of the things that you can help yourself greatly with is to provide start off with your own search. Now we provide tools through our own website, uspto.gov. And one of the things that I'm showing here is on our main page. I don't know if that's the same cover picture that we have right now, but in our under the search box on our webpage, we do have that find it fast drop down menu. And if you just hover over it, the first two things that are going to pop up are links to our patent public search tool, which is a very newly released tool, and TESS, which is, I thought I put that acronym in my notes, but TESS is you know what? It's on a slide that shows up later. TESS is the online search tool that you can use to do a search for trademarks, and I'll get into a little bit about doing some trademark searching in a couple slides here. But moving to the patent public workspace, patent public search tool first. So the reason I mention this is it's especially important that this is accessible to the public now, because this mirrors almost perfectly the same search tools that we, the examiners, have at our disposal. The key difference here, as you can see on the left side of this slide, in the red square, you see three boxes checked: one for US PG Pub, one for US PAT, and one for US OCR. So real quickly, US PG Pub, that's US pre-grant publications. So when you file a non-provisional application, 18 months following that filing, unless you otherwise say so, your application will be made public as a pre-grant publication. It is not granted, but it is published. You can of course request that your application not be published. But going back to the databases that are searchable to the public, so we have pre-grant publications, published applications. US PAT are granted US patents. And then US OCR are US optical character recognition. So those will typically encompass patents that have been published, but older patents that were not necessarily made into searchable documents previously. So the application that I have here is actually one of my own that I granted. So one of the things that I wanted to point out using this public workspace is that it does not search foreign patent applications. I don't know if their applications are necessarily made available, but certainly the foreign patents from all manner of different countries. So the reason I highlight this particular patent is it's one that I granted first and foremost. But in the larger red box, hopefully that's readable. It's pretty small on my screen, so I apologize. There's a couple things that I would like to show you about this that you can note. First, there's an application number, which you can use as a reference number. There's also a PCT, which stands for Patent Cooperation Treaty. And that is basically the application form for what will be for a application that will be on the international level. And the WO number that you see below it is the number that was granted published as. So when you see the WO number, it's not a worldwide patent, it's not a global patent, but it is published through WIPO, which is the World International Patent Organization, and it's a conglomerate of countries that are members to that organization. And so basically, there will be that number, which is essentially like a foreign patent. So the reason I make mention of this is because perhaps you filed an application, say like in 2018. Well, seeing that this 905 patent was published in 2019, that's not necessarily something that's accessible to me to use as prior art. However, if you pair it with another tool, and again, this is something that you yourself as a prospective applicant can do, you can help yourself by pairing tools. We do it ourselves as examiners. But if you pair it with another tool, for example, Google Patents, literally go to Google and type Google Patents, and it'll take you to a search bar for that. What you can do is you can find the published patent, but it will also provide you links to other countries that have published this patent. or where the applicant has filed for protection in these other countries. So, for example, in 2015, they have a publication in Denmark. In 2014, not only did they get the U.S. Uh, the US link is for their pre-grant publication, and then there's also one for Great Britain and then the WIPO publication. So using that, you can see where else, and more importantly, when else something has been published. So if you're doing your search ahead of finding your looking for your own invention, if you see something that comes up that's really, say, like close to your invention, click on the thing that is probably keep clicking and doing your research to find out what is involved in all of those other publications to see if it really truly has been done. Because if it's more than a year beyond when you more than a year in advance of when you filed your application, if you filed in 2021 and you find a document that was published in 2018, that can conceivably be used as prior art against you. All right, so I mentioned we're going to look at trademark, and TESS is an acronym. We speak an acronym, but we don't always remember, like myself, we don't always remember what they mean perfectly. But in this case, TESS stands for Trademark Electronic Search System. And as I mentioned before, from our homepage, this is also publicly available. Simply click on the TESS link, and it will take you to this site. Now, I don't have any slides beyond this as to what the interface looks like itself. And if we have time, perhaps I can actually show you that. But basically, you can conduct a basic word mark search, or you can do a word mark and design mark search. Basically, if you search, if you opt for the second option, the word and or design mark search, something that I have found particularly useful in using this site is to put your terms of interest in quotes, and that will help to call them out in your search. So, for example, I'll search Disney, Walt Disney in quotes, and then I'll search wherever they are in California. They're pretty much all over the world, but or Pixar in California. You can look for and you can select the databases um, under which you want to. So if you want to say like I can show you this in a little bit, but say like Pixar, and you can select that to be the owner name, and then you can say in quotes, say like I don't know if it's Modesto's where they're located, but Modesto, California, or just Modesto, and say owner slash address. That will help you narrow the search within the trademark database. One of the other ways that you can greatly help yourself is to just simply, again, turn to Google and just literally start by throwing your exact idea for your trademark or your trade name or your slogan into Google in quotes. Excuse me, in quotes even helps more because it will search for that exact phrase. And if there's something out there, that's a very good way to begin your search. And again, doing these searches ahead of filing for your trademark application or filing for your patent application is only going to help you because you are in effect assisting the examiner that's going to pick up your case in streamlining that search. So a couple more things about trademarks. So trademarks, one of the big IP issues that can arise with respect to your business name, your trademark, your slogan, and although a lot of times business owners are going to you're going to devote a significant amount of time to trying to come up with a really kitschy business name or slogan or whatever. Not often do people take the time to conduct a thorough search of what that trade name, mark, or logo currently being what that trade space is going to look like, what the landscape is. Is it going to be confusingly similar with something else, or is it something that's already being federally protected? So as I said, you can only help yourself by doing a search. So one of the great go-to examples that we use a lot in our presentations is Delta versus Delta. So there's Delta Airlines. Of course, it's Delta. I forget if their logo is "We'd love to fly," and it shows, but by and large, Delta, and I think you have the swoosh, the mark that you see on the side of the plane. You also have Delta Faucets, which also employs a red and blue trademark logo and is also Delta. But one is within the airline space, and the other is within the faucets. So obviously, even though they share the same name, there's going to be a very low likelihood of confusion because these two marks are completely separate from one another. So one very common misconception that comes up with, and one thing that entrepreneurs kind of wish they know, one of the things that we get a lot is that acquiring a domain name, is that going to grant me protection in lieu of a registered trademark or getting my trademark federally registered? No. Pure and simple, the answer to that is no. I apologize. I keep itching my nose, but it's allergy season here, so sorry about that. But you can, one of the things that you can do with that is you can turn your domain name into a registered trademark. Um, on the opposite side of that coin, though, registering your business name as a trademark does not guarantee you exclusive right to that domain name. So also, in conjunction with the last point on the slide, a trade name. So the TM is not equivalent, and I think I made this point clear before, is not equivalent to acquiring the trademark registration. So that second bullet point is actually like the TM versus the circle R. There's different levels of coverage. There's different levels of protection. So you absolutely want to make sure that you know which one that you are employing and know which one you are um, what's level of protection that you have at your side. So as another example for this slide before we move on, from Amazon. We all know Amazon. We all know their products and their abilities. Amazon was once known by Amazon.com, and their domain name essentially, was the same. But given their prominence, in the marketplace, they were able to just, truncate that .com from their name, from their trademark, and simply go Amazon. Everybody knows what Amazon is. In fact, I would have to look for the logo to see if they even employ the TM or the circle R anymore, because everybody knows what Amazon is, and legally, I don't know that many people challenge trying to infringe upon that mark. Um, so similarly, incorporating your business under a name of your choosing does not grant you the ability to use that name as a trademark. Rather, it simply permits you to operate your business under that name. So just by virtue of operating your business um, under a particular name does not grant you that registered trademark protection. We, the U.S. Patent and Trademark Office, offer that protection. So I think I think we kind of covered a number of these points. So with regards to some of the basics of these, you want to remember that you are not buying a trademark. You are not every trademark is registrable. Just because it sounds, fanciful, unique, looks, unique to you, does not necessarily, unfortunately, mean that it's something that's going to be able to acquire a trademark or be registered as a trademark. Any and all filing fees for information point are not refundable, and the bottom line empirical strategy with regards to pursuing trademarks is that you want to avoid a likelihood of confusion. You want it, be it font, be it lettering, be it color, um, you name it. Trademarks have a broad expanse of definition. They can be, if you've attended any of our series, you know that they can be fonts, they can be colors, they can be smells, they can be sounds. So the key point is to avoid the likelihood of confusion. You want people to remember what your goods and services are that your trademark is going to protect, as opposed to somebody else's. When you hear a lion roar, you want to remember that, maybe it's Jeff's kitty litter, and I'm not going to apply a lion roaring, because people will hear that and think, oh, MGM is selling kitty litter? No, no. So you want to make sure that there is no confusion. And under likelihood of confusion as to the source of the trademarks confusingly similar, and are the goods and services related. So going back to our Delta example, um, the name, maybe at face value, the name is confusing. What are you talking about? But once you get into what you actually see, and it can go only as far as the logo. And I think Delta faucets, actually, their logo is in the form of several drips to mimic drips of water. So once you get to that point, you readily understand that these goods and services are rampantly different. And then we covered some of the suggestions here for searching. So the USPTO database, the patent public search tool tests, and of course the internet. And then summary of search principles. Yeah, and this goes towards this. I'd say this is equally applicable to patents as well. So begin with a dead-on search. Just, I'm looking for this, and you might be surprised what comes up. Maybe not. So search words, designs alone, pictures, acronyms, everything that they stand for. So sometimes the more simple of, sometimes the simpler the search can get you some of the more of the better results, a wider array of results. Excuse me. So one of the big things that we get, and a lot of times we would get this when we go to trade shows or when we're doing back in the day, back 2+ years ago, 10+ years ago, go in COVID terms. But when we were actually boots on the ground and at shows, and when we're in hosting a booth, or they're in person amongst people who are have ideas or want to come and talk to us about inventions, a lot of times they're bursting at the seams to just disclose. In fact, uh, true story, I was at an event down in Durango, Colorado, and I was manning a booth, and I had a lady literally come up to me with a recipe book that her grandmother willed to her, and she was trying to figure out how um, to see if she could get a patent for some of the recipes, the methods of making some of these things. And while it was unfortunately a conversation that um, she was very insistent, but about what she was showing me, but not only was she showing me exactly what she wanted to do, she was also trusting the fact that I wasn't going to turn around and take this invention, even though recipes for making food are in all likelihood not won't result in a patent. The Conceptually, she was still free form telling me exactly what her intended invention was. And that's kind of brings us into our next topic here, which I kind of jokingly say, "So I have an invention," because a lot of times when family, friends, whatever, people realize that I work for the patent office, the gatekeeper of inventions that can drive commerce. It's like, so I've got this great idea. I can't, Kathleen, I don't know about you, but I don't know how many times I've been approached by that phrase. So what that is meant to tail into is, what are the risks of public disclosure? What are you putting yourself at risk for by disclosing what your invention is, what your hopeful invention is, to someone you may know or someone you may not know, or just um, at at large? So like I said, this my particular incidents happened at a um, I think it was a small business association event. But point is, there's public ears, there's prying ears. You never know who you're saying what around. So one of the big questions is, what can I say before filing? What, how do I know when I've said too much? Um, at what point does disclosing my invention to someone who's interested in helping me finance it, at what point does that constitute a full disclosure? And lastly, can I just keep it secret? Well, I'll start with the last question first, because we all know the answer to that one is, of course you can keep it secret. But a lot of times people who are trying to develop their ideas, oftentimes who are trying to develop them into businesses, they're trying to get, for example, funding from a venture capitalist, and maybe they don't have that patent under their belt yet, because truth be told, applying for a patent application is, even as a micro entity, which is a 75% discount off our patent fees, um, even that can be an expensive prospect. So a lot of times people are, you know, trying to, get their funding together, as you see crowdfunding campaigns, or they're trying to pitch their idea to a venture capitalist. How much do you say, and how much do you say to get them interested? And at what point have you said too much? Well, that at what point have you said too much? That's on you to, as the inventor, to disclose. Um, one of the things that we oftentimes discuss when we're going back to the searching of the prior art in response to applications that have been filed, is that we as examiners have free reign, essentially, to use anything that we can find in the public domain that has been made made public to use against a filed patent application. And if we come across a radio broadcast, I have personally used Facebook entries to show that something has been done before. So on that on that last example, Facebook entry, this particular company had basically advertised their product with all the benefits that were appearing in the claim set that I was looking at. So one of the absolute things you want to be careful about is who you say who you say things to, what you say, and when you say it. Um, so there are I mean, it shouldn't. I mean, you shouldn't keep every possible thing. I'm not trying to say this to scare you into keeping everything so close to the vest that it's never productive for you, but I'm merely trying to put you on, trying to make you aware that saying certain things and saying too much about something can actually harm you rather than help you. So use caution in advertising. Examples where public disclosure can be in the tangible form. If you've ever been to a scientific convention where you're doing a poster presentation, if you display an actual prototype of your invention at a trade show, for example, or if you post they say everything on the internet is forever. If you post your invention on the internet, we as examiners have access to something we call a wayback machine, an internet wayback machine. I believe it's actually a public search tool that you can use. And one of the fundamental elements of it is you can search to find out when a web page was made public and what was on that web page when it was made public. If you offer to sell your invention, depends on how much you tell about it. But if you're offering to sell your invention, a lot of times you're probably getting into a very detailed conversation about what that invention entails. A description of your invention, a newspaper article, public demonstration of your invention. If someone with a phone makes a videotape, or a videotape, I apologize. If they make a recording of your invention, you demonstrating your invention, and then 18 months later you go to file your application, if that recording is made public, that could potentially harm you. So you want to give strong consideration, about what you say, when you say it, and to whom you say it. Okay, next we're going to get into reinforcing your protection. So where to patent enforcement considerations. Um, excuse me. So some of the considerations that you want to have in the back of your mind is just like the enforceability of patents. Enforcement requires, one of the things to keep in mind is, so once you acquire your trademark, and of course this extends to copyrights and how you may or may not enforce your trademark, your trade secrets internally. But once you acquire your patent, once you acquire your trademark, your registered trademark, enforceability of patents, enforceability of IP. It says patent, but this extends to all IP in general. Enforceability of your of your IP is going to fall to you, the owner. We safeguard inventions in terms of what has been done in the past. Um, Once we have granted that IP, we are basically saying this is something that is new, this is something that is innovative, this is something that is unique, fanciful, never been done before, essentially. So this new corner of intellectual property belongs to this person. That is typically where our part of the part of the transaction ends. Once you have that intellectual property under your belt, it is your job as the owner of that IP to maintain it, to police it, and to defend it. I believe there may be some bits of interaction that we can do, um, if it's brought to our attention, but it needs to be brought to our attention. We do not actively pursue and say, hey, you might want to take a look at this. Looks like someone's trying to invent the same thing that you did. They're trying to infringe on what you're doing. That's not our, um, that's not our, within our purview. Some of the remediations to that is, if you discover that, you can take legal action, of course. Also, you can, if you make the discovery yourself, you can enter negotiations to either sell the IP to the person, or you can enter an agreement with them to license it. And if they're going to continue to try to use your invention, one of the things you can do is it's like, well, in lieu of legal persecution, how about we just license it to you and you pay us a royalty and we'll allow you to continue using my invention. So some of the processes that exist, and again, as I mentioned before, we're not advocating for companies in particular. In this case, Amazon is kind of an easy broad side of the barn to go to just because they are so prominent in the market space, but they do in the marketplace, but they do have their own policing, uh, internal policing processes where it pertains to inventions that are inventive products or new products that are being sold in their marketplace. So, for example, the neutral patent evaluation process was a process that was created by Amazon of itself. Takes into this has absolutely nothing to do with any of the processes or policies that are um, embraced by the USPTO. This is something that is completely Amazon contained. So what they have is, if you are a seller on on Amazon, you're selling your product on Amazon, and you discover that you've got, through your own policing and searching on Amazon, you discover that, say, 30 other people are selling your product and not paying you a dime for doing it. In fact, they're using the same pictures that you use to advertise your product. They're selling your product and they're making money off of it. So what you can do is you can approach Amazon. Again, I think you have to be part of their inner circle. They're selling, um, have an account with them. But what you can do is you can approach Amazon, um, each party of the in the case. So if there's you and one other person, or if there's you and three other people, every party in this particular issue would pay 4,000, make a $4,000 deposit. The accuser pays once. So if you have four people, for example, who are trying to sell your product, you pay once, and each of the accused sellers pay once. You don't pay 4,000 for each seller, is what I understand. It's limited to one patent claim within one expired U.S. utility patent. So this might be a bit of a bottleneck in some cases, but essentially, what this process allows is for a seller to approach accusers through a neutral setting, through a third party evaluation process, and basically have the inventions, have the products evaluated to see who is the true owner of the intellectual property. And so it's, as I said, it's limited very much to one claim in a US patent, and each of the claim may list up to 50 products. So if you have, for example, 50 patents, one claim, 50 different products, it can, as you can imagine, it might get voluminous pretty quickly. It allows for expeditious and voluntary involvement on both sides. So that being said, if you are the accused and you elect not to, um, partake in the process when notified, Amazon will simply just discontinue, um, you allowing to sell it on their website. However, you can enter into it, and if you are whoever comes out on top with the negotiating, with the evaluation, they will, not have to. They will get their deposit back, and they will be allowed to enter negotiations for remediation. So, as I said, one of those remediations could be that you allow the person who is selling your product to continue to do it and enter a licensing negotiation. You can shut them down. There are processes for allowing you to protect your IP in a market space, and the neutral patent evaluation process is one such process. With regards to trademark, sorry, Amazon, but Amazon also does have what they call Project Zero, and uh, this is more directed towards trademarks. And basically, what they are looking to do is embrace technology and brand recognition of trademarks, logos, and everything associated with trademarks, to essentially create learning systems within the Amazon system to recognize trademarks, recognize where they are registered, um, have their systems learn the sourcing of these so that they can self-correct um, through serialization and essentially allow counterfeit products or products that are infringing to be removed from the marketplace before they even have a chance to go out the door and be sold by infringing parties. That does also come as the research I did on this also comes with you must be eligible. Eligibility comes with brand enrollment with Amazon brand registry, and of course you do need to have an actual registered Circle R registered trademark with the government. Some of the other one of the other organizations that we do also promote stopfakes.gov. Um, Basically an international trade through the International Trade Administration, the U.S. The DOC manages an organization called stopfakes.gov to assist in protecting ports of entry from, well, not ports of entry, that's uh, the CBP, um, but to enforce IP rights against counterfeits. They probably work in conjunction with CBP, Customs and Border Patrol, and essentially establish a network of information so that um, products that do come in over across our borders through our ports of entry in the country can be monitored for and removed from the marketplace before they make it out there. Um, Avoiding some of the common mistakes that can easily be avoided. So confidentiality can help avoid making an invention public prior to a patent application. It's a lot of P's. I apologize. You can be familiar with key dates and deadlines, particularly when you're dealing with the filing of your patent and trademark registry applications. Be very familiar with your key dates and deadlines. You don't want an application to go abandoned. Um, Things like that can be revived, but again, they come with a price. So one of the common mistakes people fail to understand or grasp is how much things cost and what missing deadlines can, um, some of those costs can actually pile up as well. And then recommend securing the services of a registered patent attorney or agent. Um, so as a U.S. Patent and Trademark Office, we cannot officially recommend or suggest or advise you is the key buzzword. We cannot advise you to seek counsel. However, part of the information that we offer is to let you know what sort of services can be garnered from registering approaching an attorney or an agent. And essentially the short version is if you are going to retain an attorney or an agent, part of what you're paying for in their fee is their knowledge base and everything that they went to school for to learn and to they are schooled, they are experienced in navigating the pretty weighty waters of what IP can entail, and to go it alone can be a daunting task. If you're to secure patent attorney or agent, they can for their price they can help you negotiate those waters. Lastly, one of the big things that we always come to, and it's usually always at the end of our presentations, what support and resources are available to me. So we come back to this, our um, our cover page again, our landing page at the USPTO. So you see it there, you can see the find it fast logo, but somewhere always the picture is always going to change, but usually on our almost always on our landing page, you can, like just text search it, access our free services. And if you click on that hyperlink, it will take you to a page. You'll know you got there correctly because you'll see these four logos. And what if you follow this web link, what you will see is a just the entire pantheon of our free services, and it will have everything from our fee schedule to our upcoming events to our links to the Inventor Assistance Center, to the Electronic Business Center, to pro bono services. And one of the reasons I want to mention Patent Pro Bono program is because Arizona, University of Arizona in particular, um, oops, where's that slide? So Arizona is University of Arizona has the Arizona Public Patent Program, under the University of Arizona and IP Entrepreneurship Clinic in cooperation with the USPTO. So the hub, the go-to place for the patent pro bono program, is right on your doorstep, and you are the gatekeepers of that for the entire state of Arizona. So, launched in 2011, the patent pro bono program is currently offered in all 50 states. Um, Regional program hubs and administrators attempt to match, and will attempt to match inventors and small businesses who qualify based on income threshold, et cetera, with local patent agents and our attorneys to practice before the law, before the USPTO. And so if you qualify for it, something you would need to look into as a small business owner or an individual inventor is if you qualify for the patent pro bono program in your area. And then lastly, of course, we do have a liturgy of websites that you can go to. But honestly, if you go to this access our free services site on our landing page and get to the page where you see these icons at the top, there's literally a list with a whole host of hyperlinks that will take you to a number of our free services. And if we have a moment here, I would actually try to navigate to that. So apart from that, that is my presentation. And let me.
Oh, for good Lord. Paul, do
we have any questions that have gone unanswered at this point?
Paul, I have to ask, since we're recording this, the people that are getting the recording, will they have access to the chat? Since there were a few questions that I've answered. If not, we can repeat them and have them verbally answered so that they're available to people who are watching the recording.
Yeah, I think repeating them for the recording would be great. We could also make them available via text as a transcript too, but if you could do that would be great.
All right, so the first question is, what's the ballpark for patent filing costs? I will answer that because I actually have the actual figures up. So for microentity status, which is generally about income of $200,000 or less, generally this can change because it's based off of so many times the federal poverty or average income. It's about $455. Now this may change in the future because our agency does have fee setting capabilities, but it goes all the way up to, for say, a large entity, so it will be a very large corporation, is $1,800-ish. It's 1,820 if you want to know the exact amount. However, remember when Jeff was talking about a provisional versus non-provisional patent applications? So the $455 microentity fee, that's for the non-provisional patent application. That's the one that gets examined by an examiner and could potentially become a patent. The provisional, which gives you a 1-year time window in which to file a non-provisional, gives you a 1-year earlier filing date, as it were, is $75. So you can see it's drastically much cheaper, but doesn't require claims, and in and of itself does not get published, nor does it get examined. So, and that goes up to $300 for a large corporation. So you can imagine we can get quite a few of those from large corporations. So it's very cheap compared to doing the full examination just to buy people a year time. So Jeff's going to show that. I'm going to scroll over to the next question while he's showing
real quickly
it
while she's
live.
getting there. This is the page to which I was referring, and as you can see below those icons, you have all manner of services: law school, clinic certification program, patent trademark resource centers, patent pro bono program, so pro se assistance program. These are all the pro se, the pro bono, and the law school certification program. These are all assistance services that are designed to be made available to people who are just starting out, people who are of lower income and can't afford the exorbitant prices that can sometimes, as I said, filing for a patent application is not a cheap endeavor, nor is it a short one. But if time and money are a consideration, these are programs that I encourage you highly to look into that can offer that sort of assistance for a cost-effective price point. So
we also have to add that, just to emphasize that these two programs, while they will provide legal advice, they don't pay the patent fees. That's why it's important to understand the microentity fees. So that tails into the previous question. So next question is, when is it okay to go to patent agent versus when you must use a patent attorney?
Oh, I think I think a good analogy to that is I hope it's an accurate analogy, but say like a doctor with an MD versus like a physician's assistant. As I understand from that analogy, is like they essentially kind of do the same work. The patent
One
attorney
just
has a
has more degrees.
JD, yeah, and the patent agent um, doesn't necessarily have a law degree. In fact, if they had the law degree, they wouldn't be calling
It would
themselves an
be a
agent. But
patent attorney.
one of the potential benefits of seeking out a patent agent is a lot of times they're former examiners. So if you, it's quite possible, again, do your research for who you want to pursue to help you with these things. But if you feel someone who's got an inner working knowledge of what the patent agency, the U.S. Patent and Trademark Office, from a former examiner standpoint, that could also be a beneficial tool to you.
So the actual technical definition is a patent agent and a patent attorney. Both are registered and have passed a patent bar that the USPTO administers. However, a patent attorney typically has a JD, but they also are barred in the state that they practice in. So it's a different, it's a state bar versus the national USPTO bar. So a patent agent and a patent attorney both can help you prosecute, meaning apply for a patent. But a patent attorney can also help you do something called litigation, where if you're trying to sue someone or someone's suing you for infringement in court because they're barred in the state. So that's the technical difference between the two. So short answer for the long answer that we had is, if you're trying to apply for a patent, it actually doesn't really matter. It's who you prefer.
Each are equally approachable because they need
yes.
to be registered to practice before the office.
Correct.
And
okay, so next question is, and I don't know how exactly to answer this, but what amount of time should people expect or plan for when filing a patent? I think the question is, how long would it take to actually write up the patent application, not how long it would take to examine, but we can answer both of them. So I answered
how long
that a
it
good
would take
analogy.
To write the patent application will take as long as you need. Yeah.
My analogy
exactly.
here is, you think of it as writing a research paper for publication in a major publication. You need to make sure that it's in the proper form and you have the proper documents written out, and that you're describing everything appropriately. But how long that takes you, it depends, because if you have a very complicated invention, you might have to have a much longer specification than if you have something that's mechanically simple but to your eyes novel. And it depends on how much things you already have prepped. So if you have drawings, for example, if you need drawings and you have drawings that are already labeled, right, then it might not take you all that long. But the second part of the question, which may or may not be what Paul was asking, is how long it actually takes to get examination. Just pulling up our dashboard, and we have an average. I don't remember what it's at, but it's at the 20-something month mark, I'm gonna say.
Oh goodness, I usually have this. I'm so sorry. I usually have this.
We also have a lot of data that goes through our office. So expect it to take several months.
It's a double-edged sword. One of the benefits of having a lot of data is that we're full of information. Unfortunately, we're full of information.
But typically it could take several.
I think the last, honestly, I think the last average
months.
I saw was about 18 months and change to have your application on average. This can vary from tech center to tech center, but on average, about 18 months to have your application looked at.
Okay, yeah, no, that's very helpful, because I think that's an important part of the planning process, right?
There we
It's going to happen.
Oh, there it is.
Absolutely.
And
there we go.
It all depends. I mean, my docket right now is, I'm looking at things from 24 months ago that were applied, but I have a friend that works in a different area. She's looking at stuff from 6 months ago. There's a lot of factors that go into that. Not the least being how many examiners they have in that area and how many applications they have. And that's hard for us to tell you, because we're just examiners. We don't have the pulse on like what everyone else is doing. So
Great.
Jeff has actually included in the notes the dashboard. You can check that out yourself. That's publicly available. They have it based off of what we call tech centers, because we all get broken up based off of what areas we're in. So Jeff and I aren't in the same tech center. I do mechanical, Jeff does chemical and pharmaceuticals. So we're in completely different tech centers. My area covers all the
Drugs.
mechanical things. He does drugs. I'm the reason why oil and gas
Yep.
gas is so expensive, because I do petroleum engineering.
Well, I appreciate your time today. I think we definitely need to wrap this up because I know we were planning on 3 o'clock being the end point.
Sure.
So again, thank you very much, Jeff and Kathleen, for all the great information. We will get this posted on our website as a recording and then also the transcript of the chat. And then I appreciate you, Kathleen, answering the questions as well in the video format too.
All right.
But thank you all very much for joining us. We will have another office hours with the USPTO coming up in 2 weeks. And then also we will have a careers panel as well. So you can learn more about what types of career opportunities or internship opportunities are available. But I'm going to go ahead and stop the recording now. And thank you again very much.
All right.